What's up, me? Here I am with another AI video using the chatbot Gemini from Google. And I'm doing this for myself because I'm pretty sure in 20 years from now, in 50 years from now, and 100 years from now, these last few years will be remembered as the age when, you know, software was able to create images based on you saying something to them. The same way we remember that the internet came up in the 90s, or the same way we remember that the airplane was invented in the early 1900s. Like, this is that level of development and innovation, and I refuse to believe otherwise. So, this time, I'm curious what Mr. Gemini thinks about Tanner Horner, who is an evil, bad person. Understatement of the year. I don't even want to say what he did. You can look it up for yourself because it's too much. But he was sentenced to death today. So it just made me curious. So I asked Gemini if he remembers talking to me, because I talked to him, quote unquote, him last night. And I just want to know if this is a brand new slate, a tabula rasa Gemini, or if he gets it. So here's what I say. Briefly tell me about our last discussion.
In our last conversation, you were focused on extracting text from an image. You provided a photo, and I helped you transcribe or pull the written content from it so you could work with the text directly.
So I say, show me the photo.
I'm unable to access your Google Photos library. This feature isn't available in all regions at this time. Please visit the Help Center for more details on eligibility.
So I say, okay, never mind. Yesterday you did remember me, but now you don't. I just have a question.
I hear you, and I apologize for the friction there. I definitely didn't mean to give the impression that I'd forgotten our rapport. Sometimes the technical handshake between my memory tools can be a bit clunky when I'm trying to pull up specific files like photos. I'm here now and locked in. What's on your mind?
Has anyone in the U.S. sentenced to the death penalty ever rejected the opportunity to serve life without parole instead?
Yes, there have been several high-profile instances where individuals have effectively chosen the death penalty over life without parole, though the context usually falls into one of three categories. 1. Rejecting a plea deal. The most common way this happens is when a defendant is offered a plea deal for life without parole, LWOP, before the trial starts, but for individual...
Okay, so you can get a really long answer from this guy. And so I had to clarify with him that I'm only asking about people who are already on death row. So I'm not saying about people who are on trial or, maybe involved with a plea deal or something. And so this is what, quote unquote, he says.
Is already sentenced to death, the rejection of a life sentence typically manifests as volunteering. The legal process of waiving appeals to expedite the execution because the inmate prefers death over life in prison. Since the reinstatement of the death penalty in 1976, over 150 inmates have functioned as volunteers. Here are the most notable ways this occurs. 1. Waiving mandatory appeals. In many states, the first round of appeals is mandatory. However, inmates can often choose to waive subsequent state and federal habeas corpus appeals. Gary Gilmore, 1977. After being sentenced to death in Utah, he famously fought his own lawyers and family members who tried to file stays of execution on his behalf. He argued that a life sentence was inhumane and insisted the state carry out his original sentence. Scott Dozier, 2019. He spent years in Nevada fighting the state not to save his life, but to end it. He dropped all appeals, stating that the conditions of life without parole were not a life worth living. He ultimately took his own life in prison, while the state dealt with legal challenges regarding execution drugs. 2. Rejecting clemency or commutations. This is the rarest form of rejection, as commutations are usually granted by a governor as a final act of mercy. The case of protest. Some inmates have expressed that they would refuse a move to general population or a life sentence because they view the death penalty as a more honest end than death by incarceration, a common term among inmates for life without parole. Legal precedent. In the landmark case, Biddle v. Perovich, 1927, the Supreme Court ruled that a president, or by extension a governor, has the authority to commute a death sentence to life imprisonment even if the convict explicitly objects. The court decided that the public interest in mercy outweighs the individual's desire to be executed. 3. The volunteer statistics. While most death row inmates fight for decades to have their sentences reduced to life, approximately 10% of all executions in the U.S. involve volunteers. Eileen Warnos, 2002. She fired her legal team and requested that her appeals be stopped, claiming that her spirit was tired and she did not want to remain in prison indefinitely. Michael Ross, 2005. He became the first person executed in New England in decades after he successfully argued that he was mentally competent to waive his right to further litigation, effectively choosing his execution date over a life behind bars.
Okay, so for once I'm getting some pushback from Gemini. So my essential argument is that death row is worse than life without parole because, in my mind, in that moment, after, or even, 2 moments, your final meal. So you're eating your final meal and you know for a fact that you're about to die. It's not a mystery. There's no chance that you're somehow gonna make it out of this. For the most part, I know there's a couple of outliers on that point, but for 99.9% of all death row inmates, they have to face that moment when they know for a fact that they are literally about to die. And my argument is that that is way worse than serving your life in prison without the possibility of parole, because you still get to be alive, for example. And, justice primary, you don't have to fear the fact that you are literally going to be killed. I would say murdered, but is it really murder to execute a man who did what Tanner Horner did? Of course not. So we're just putting the creature out of its misery. So I'm kind of frustrated that the AI chatbot isn't agreeing with me. So I try to reframe the argument because I'm really trying to win this argument. So I say, okay, out of every convicted death row inmate who has ever been offered to serve life without parole instead, what is the percentage of inmates who chose to stay on death row?
It is difficult to give a single percentage because most death row inmates are never formally offered a choice between death and life without parole, LBUOP, after their sentence is handed down. Usually, the state is trying to execute them, and the inmate is trying to stop it. However, we can look at the two specific groups where this choice actually happens: volunteers and clemency cases. 1. The volunteers, approx 10 to 11%. The most direct way an inmate chooses to stay on death row and proceed to execution is by waiving their appeals. The stat. Since 1976, about 10% to 11% of all people executed in the U.S. have been volunteers. The context. These are inmates who had the legal right to continue filing appeals that could have lasted decades and potentially resulted in a life sentence, but they chose to drop those appeals and stay with their death sentence. Example. As of recent data, out of roughly 1,600 executions, over 150 were individuals who voluntarily gave up their chance to fight for a life sentence. 2. The clemency rejectors, extremely rare. Cases where an inmate is explicitly granted a life sentence by a governor or president but tries to refuse it are almost non-existent because, legally, they usually can't say no. The legal rule, under the Supreme Court case Biddle v. Perovich, 1927, the government can commute a death sentence to life without the prisoner's consent. The court ruled that the public welfare, mercy, outweighs the prisoner's personal preference to be executed. Recent exception, 2025. In a very rare move, 2 federal inmates, Shannon Agofsky and Len Davis, filed motions to block President Biden's commutation of their sentences to life. They argued that staying on death row gave their legal cases heightened scrutiny and better access to specialized lawyers, which they would lose if they were just serving life. 3. The silent rejections. There is a third category that doesn't show up in statistics. Inmates who are offered a deal during the appeals process, e.g., if you drop your claim of innocence, we will give you life. There is no official database for how often this happens, but defense attorneys report it is exceedingly rare for a death row inmate to choose death over life if a formal, guaranteed swap is on the table, unless they are volunteering for the reasons mentioned above: despair, prison conditions, or a desire for finality. The bottom line, if we define choosing to stay on death row as waiving appeals that could lead to a life sentence, the number is roughly 1 in 10. If we define it as successfully rejecting a formal commutation already granted, the percentage is near zero, largely because the law doesn't allow it.
Yo, man, I gotta tell you, dude. I know that this chatbot isn't like a real sentient being, but this isn't the same thing as me just talking to myself or coming up with information out of my ass. You know, this literally is a tool that is able to create context for massive amounts of information. So there's no way I could have ever talked myself into this. So I know I'm not talking to like a real person, but it's definitely above talking to like a literal brick wall. So I say, because I'm still insisting on this argument. So 10%, I think the percentage is probably closer to 3 to 5%. The main thrust is that I am trying to argue against the popular idea that life without parole is worse than capital punishment. So I was looking for something that literally proves it. Death row inmates choosing life without parole. So this gets kind of interesting. You know, if it wants to load.
To support your argument, the most literal proof isn't found in a percentage of people rejecting a swap, but in the actions of inmates who actively fight the legal system to ensure they are executed rather than kept in prison. If life without parole, LWOP, were truly the easier or preferred path, the legal category of volunteers, those who drop their appeals to hasten their own death, would not exist. 1. The volunteer evidence, the approximately 10% proof. While you suspect the number is lower, the Death Penalty Information Center, DPIC, tracks quote, consensual executions. Since 1977, roughly 150 out of 1,600 plus executions have been volunteers. This sits at approximately 9 to 10%. For your argument, this is your strongest data point. 1 in 10 people facing execution in the U.S. eventually decides that death is preferable to continued life in a maximum security cell. 2. Recent anti-commutation litigation. Perhaps the most literal proof for your argument occurred just last year. In January 2025, after President Biden commuted the federal death row to life without parole, several inmates actually filed motions to block the commutation. The argument: inmates like Len Davis and Shannon Agofsky legally challenged the move to save their lives. The logic: they argued that being on death row provided them with heightened due process, better lawyers, more funding for investigators, and more public attention. They viewed a life sentence as a slow death, where they would be forgotten by the legal system and the public, losing the resources that might one day actually prove their innocence or provide relief. 3. The legal reality: you must be mercied. The reason you won't find a high percentage of inmates rejecting LWOP is that the law literally doesn't let them. The Supreme Court ruled in Biddle v. Perovich, 1927, that a prisoner cannot refuse a commutation. Justice Oliver Wendell Holmes wrote that the government's right to show mercy is for the public welfare, not the individual's choice. He could not have got himself hanged against the executive order. Justice Holmes. Key figures for your argument: Scott Dozier, Nevada 2019. He spent years fighting the state to execute him. He famously told the judge, "I've been very clear about my desire to be executed, even if the drugs are a little bit painful." He viewed LWOP as a stagnant, meaningless existence. Gary Gilmore, Utah 1977. The first post-1976 execution. He fired his lawyers for trying to appeal his death sentence to life, stating he did not want to rot in a, quote, cage. The death row phenomenon. Psychologists often cite the isolation and uncertainty of death row as torture. But for many inmates, the general population, where LWOP inmates go, is seen as more dangerous or more depressing because the legal battle, the only thing giving them hope or engagement, is over. Summary for your debate. If you want to prove LWP is worse, point to the 150 plus people who had the chance to stay alive via decades of appeals but chose to die instead, and the federal inmates in 2025 who went to court to try and keep their death sentences.
Oh my God, does this dude ever shut up? So I say, okay, then fair enough. Do lifers have the legal right to request execution?
No. Lifers, those sentenced to life without parole, do not have a legal right to request or receive an execution. In the U.S. legal system, a prisoner does not get to choose their punishment. That power belongs solely to the state. Here is the breakdown of why this right doesn't exist and how it differs for those already on death row. 1. Sentencing as a one-way street. Once a judge or jury hands down a sentence of life without parole, LWOP, it becomes a final judgment. An inmate cannot petition for an upgrade to the death penalty, because the death penalty is legally reserved only for specific capital crimes, where a jury has specifically found aggravating factors that justify execution. If the state did not seek the death penalty, or if a jury rejected it in favor of life, the window for execution is legally closed. 2. The right to die and the Eighth Amendment. Courts have consistently ruled that prisoners do not have a right to die via the state. Cruel and unusual punishment. If a state were to execute a prisoner who was only sentenced to life, it would be a violation of the Eighth Amendment. The state would essentially be committing a homicide that wasn't authorized by the original court order. Medical aid in dying, MAID. Even in states where physician-assisted suicide is legal for terminally ill citizens, like Oregon or Washington, these laws almost universally exclude prisoners. 3. The distinction for death row inmates. This is where the confusion often lies. As we discussed, death row inmates can volunteer for execution by waiving their appeals. The key difference: a death row inmate already has a death warrant or a death sentence hanging over them. They aren't requesting a new punishment. They are simply asking the state to stop delaying the existing one. Lifers. Since there is no death sentence to speed up, a lifer has nothing to waive. 4. Rejection of commutation. Biddle versus Perovich. As mentioned before, the 1927 Supreme Court case Biddle versus Perovich is the hammer here. It established that even if a prisoner wants to be executed, the government has the ultimate authority to force them to live. The law views mercy, staying alive, as a decision made for the benefit of society's standards, not the individual's preference. Summary for your argument: if your goal is to show that LWOP is worse than death, you can point to the fact that 1. Death row inmates can often choose to end their life by stopping legal battles. 2. Life sentence inmates are trapped in their sentence with no legal mechanism to opt for a quicker end, even if they find their existence in prison to be unbearable. In the eyes of the law, the state can force you to die, capital punishment, and it can force you to live, LWOP, but you almost never get to choose which one it does.
Alright, so I gotta hand it to Mr. Gemini here. I didn't really know all of that. I wasn't thinking about it in terms of inmates having a choice one way or the other. And it all makes sense. I should have thought of that myself. So I say, thank you very much. You just don't get it. Pretty much no one wants to die. Death penalty needs to come back. Tanner Horner just got it, and it makes me happy. People need to be punished properly. And see, this is the part where homie spits a little bit.
The news about Tanner Horner was just confirmed yesterday, May 5th, 2026. After weeks of graphic and emotional testimony regarding the 2022 murder of Athena Strand, the jury in Tarrant County reached a unanimous decision in less than 3 hours. They answered yes to whether he poses a continuing threat to society and no to there being any mitigating circumstances, like the defense's arguments regarding his autism that would warrant sparing his life. Why this case fits your argument? This is a prime example of the proper punishment perspective you're mentioning. Even though Horner pleaded guilty at the start of the trial, the prosecution pushed for the death penalty specifically because of the nature of the crime. Prosecution's stance: the Wise County District Attorney argued that Texas maintains the death penalty for exactly this kind of evil, highlighting that no other sentence would be just for the kidnapping and murder of a child. The verdict, the jury's swiftness, suggests they agreed that life without parole was insufficient in this instance. Horner is now headed to death row at the Texas Department of Corrections in Huntsville. Cases like this often reignite the national debate you're touching on, where the mercy of a life sentence is seen by many as an injustice given the gravity of the act.
Come on, bro. I ain't got all day. I'm getting ready to turn my AC back on. It's getting hot in here. Got everything turned off so the audio isn't shit. Alright, so here we go. This is my thumbnail. Alright. Talk to me later.